Warm greetings everyone. I am Dr. Pawandeep Kaur from Khalsa College of Law, Amritsar. The topic of our today's discussion is making of Indian Constitution and its salient features. Dear friends, we will discuss this module into two parts. In the first part of this module, we will discuss the making of the Constitution, and in the second part of this module, we will discuss the salient features of the Indian Constitution. So friends, let us begin with the learning outcomes of this module. The present module will make you acquainted with the Constitution of India, evolution of the Constitution of India, framing of the Constitution of India, sources of Indian Constitution and salient features of the Constitution of India. So friends, the evolution of human society clearly shows that man cannot, as a general rule, live in isolation, but likes to associate himself with his fellow men to satisfy his instinct of self-preservation. In the early stages of the development of human society, these groups existed in the form of families, clans and tribes, which finally gave shape to the organized state. The states, like the preceding tribals, organizations also aims to secure peace and security for its people. It is therefore imperative that it must be ordained with certain power and authority to ensure the continuance of the legal order. This power obviously can only be vested in a specified person or group of persons, and to be effective must be organized by certain rules. It is essential for the existence of the state that it frames out rules regarding the authorities competent to exercise the power of the state, the principles governing the exercise of such power, the procedure for the exercise of such power, and the rights of the individual as against the authorities of the state. Dear friends, now I would like to discuss that what is the Constitution. A Constitution is the rule book for a state. It sets out the fundamental principles by which the state is governed. It describes the main institutions of the state and defines the relationship between these institutions. For example, between executive, legislature and judiciary. It places limits on the exercise of power and sets out the rights and duties of citizens. The legal foundation of a polity, organization or other sort of institution is its constitution, which is a collection of fundamental principles or recognized precedents that typically establish how that body is to be governed. The term written constitution refers to a group of legal papers that contains these principles. The term codified constitution refers to a text that contains all of these principles in one comprehensive document. One famous example of an uncodified constitution is that of United Kingdom. Instead, it is stated in various major legislative acts, legal rulings and treaties. The Constitution applies to several organizational levels, including corporations and unincorporated associations as well as sovereign nations. In that, it would specify how that organization is organized. A treaty that creates an international organization also serves as that organization's constitution. A state's constitution establishes the guiding principles, the process and the people who can make laws inside that state. Some constitutions, particularly those that have been codified, also serve as a check and balance on state authority by defining boundaries that a state's leaders are not allowed to violate, such as fundamental rights. It would, however, be more appropriate to define the constitution of state as the pattern of its political organization and the body of law which govern the relations between various organs of the state as well as relation between these organs and the citizens of the state. Friends, further we will discuss the evolution of the Indian Constitution. having analyzed the meaning of the term constitution and its significance in defining the organization and functions of the state, it would be proper to examine the evolution and genes of the Constitution of India. It is well known that Constitution of India is the product of a historical process. India's constitution was drawn up under very difficult circumstances. The making of constitution for a huge and diverse country like India was not an easy task. At that time, the people of India were emerging from the status of subjects to that of citizens. The country was born through a partition based on religious differences. This was a traumatic experience for the people of India and Pakistan. At least 10 lakh people were killed on both sides of the border in partition-related violence. There was another problem. The British had left it to the rulers of the princely states to decide whether they wanted to merge with India or with Pakistan or remain independent. The merger of these princely states was a difficult and uncertain task. When the constitution was being written, the future of the country did not look as secure as it does today. The makers of the constitution had anxieties about the present and the future of the country. The constitution is a living document, an instrument that makes the government system work. A constitution is the highest law of the land, which defines and limits the powers of the government and its various branches vis-a-vis each other and the people, and provides a strong foundation for a state based on the rule of law. The design of a constitution and its process of development can play an important role in peaceful political transition and post-conflict peace building. It can also play a critical prevention role. Constitution making presents movement of great opportunity to create a common vision of the future of a state, the results of which can have profound and lasting impacts on peace and stability. The Constitution of India is the supreme law of India. It lays down the framework defining fundamental political principles, establishes the structure, procedure, powers and duties of governmental institutions, and sets out fundamental rights, directive principles and the duties of the citizens. It is the longest written constitution of any sovereign country in the world, containing 448 articles in 25 parts, 12 schedules and 105 amendments. Besides the English version, there is an official Hindi translation. Dr. B.R. Ambedkar is widely regarded as the architect of Indian Constitution. Dear friends, moving further, now I would like to put light upon the process of framing of the Constitution of India. The concept of framing an Indian constitution is not the result of instant inspiration and observation from other countries, but itself it is the significance of emergence. The seeds of framing a constitution had already been sowed in India 2 centuries before the actual roots of the drafting an Indian constitution uprooted. The difference between the two was that one was imposed by imperial power and the other by the body of the eminent representatives of the people who sought to improve upon the existing system of administration, making a retrospect of the constitutional development indispensable for a proper understanding of this constitution. The drafting of an independent constitution for India and the idea of Swaraj had been already put forward by Mahatma Gandhi as early as 1922, as the people of India were determined to govern by themselves and not by the mercy of gift by British Parliament. On 9 December 1946, the first session of Constituent Assembly was organized and the expert committee was appointed on July 20, 1946 by Indian National Congress to prepare material for the Constituent Assembly. The Constituent Assembly set up 13 committees for framing of Indian Constitution, and based on reports of these committees, a draft of the Constitution was prepared by the 7 members of the drafting committee under the chairmanship of the Dr. B.R. Ambedkar. From a historical purview and from taking reference and observing the parliamentary speeches and debates at the time of drafting a constitution, it is worth questioning about the borrowing of Indian Constitution. The drafting of a document called the Constitution was done by an assembly of elected representatives called the Constituent Assembly. Election to the Constituent Assembly were held in July 1946. Its first meeting was held in December 1946. Soon after, the country was divided into India and Pakistan. The Constituent Assembly was also divided into the Constituent Assembly of India and that of Pakistan. The Constituent Assembly that wrote the Indian Constitution had 299 members. The Assembly adopted the Constitution on 26 November 1949, but it came into effect on 26 January 1950. To mark this day, we celebrate 26 January as Republic Day every year. Dear learners, it is very important to know the sources of Indian Constitution. The Constitution of India was drawn from several sources: the Government of India Act of 1858, the Indian Councils Act of 1861, 1892 and 1909, the Government of India Acts of 1919 and 1935, and the Indian Independence Act of 1947 were among the legislation whose provisions were incorporated while keeping in mind the needs and situation of India. People in India have the assurance that they will live in a free and just society owing to the rights outlined in the Indian Constitution. The Constituent Assembly passed the Constitution on 26 November 1949 and it became effective on January 26, 1950. The foundation of Indian Republic is the Indian Constitution, which is vital and essential. The sources of the Indian Constitution are varied and diverse, reflecting India's long history and cultural traditions. Overall, the Indian Constitution is a unique blend of various sources, reflecting the country's diverse culture and historical traditions as well as its aspirations for a democratic, secular and egalitarian society. As we all know that Indian Constitution is a borrowing bag, so here is a list of sources: Federal Scheme, Office of Governor, Judiciary, Public Service Commission, Emergency Provisions, Administrative Details have been borrowed from the Government of India Act 1935. Concurrent List, Freedom of Trade, Commerce and Intercourse, Joint Sitting of two Houses of Parliament have been borrowed from the Constitution of Australia. Federation with a strong centre, vesting of residuary powers in the centre, appointment of state government by the centre, advisory jurisdiction of Supreme Court have been borrowed from the Constitution of Canada. Directive principles of state policies, nomination of members to Rajya Sabha, method of election of the President have been borrowed from the Constitution of Ireland. Procedure established by law has been borrowed from the Constitution of Japan. Fundamental duties, ideals of justice in preamble, that is social, economic and political, have been borrowed from the Constitution of Russia. Parliamentary form of government, rule of law, legislative procedure, single citizenship, cabinet system, writs, parliamentary privileges, bicameralism have been borrowed from the United Kingdom. Fundamental rights, independence of judiciary, judicial review, impeachment of president, removal of Supreme Court and High Court judges, post of vice president have been borrowed from the Constitution of USA. Dear friends, moving further, now I would like to put light upon the salient features of the Constitution of India. The Indian Constitution opens with the preamble. The Constitution's aims, goals, and fundamental precepts are outlined in the preamble. These goals, which follow from the preamble, have influenced the key elements of the Constitution, both directly and indirectly. According to the requirements of the nation, our Constitution has incorporated the best elements of the majority of the major international constitutions. Despite including elements from nearly every constitution in the world, India's constitution stands out from those of other nations due to several key characteristics. Here is a detailed description on the salient features of Indian constitution. First one is lengthiest written constitution. There are two types of constitutions, written like American Constitution and unwritten like British Constitution. The Indian Constitution holds the title of being world's longest and most comprehensive constitution to date. In other words, of all the written constitution in the world, the Indian Constitution is the longest. It is an extremely thorough, intricate and extensive document. Drawn from various sources, the majority of the provisions of the Indian Constitution were taken from other nations' constitution as well as from the Government of India Act 1935. Dr. B.R. Ambedkar proclaimed with pride that Indian Constitution was drafted after ransacking all known constitution of the world. Blend of rigidity and flexibility. There are two types of constitution, stiff and flexible. Rigid constitution like American Constitution must be amended through a certain process. Flexible constitution like British Constitution, for instance, can be changed in the same way that regular laws are produced. The Indian Constitution is a special illustration of how rigidity and flexibility may coexist. Federal system with unitary bias. Federal structure of governance is established under the Indian Constitution. Every feature of a federation is present, including two governments, division of powers, a written constitution, supremacy of the constitution, its rigor, an independent judiciary, and bicameralism. The Constitution of India is federal in form but unitary in the spirit and quasi-federal. Further, parliamentary form of government. The British parliamentary system of government has been chosen by the Indian Constitution above the American presidential system of the government. The presidential system is founded on the notion of the separation of powers between two organs, whereas parliamentary system is based on the idea of cooperation and coordination between the legislative and executive organs. The Westminster model of governance, responsible government and cabinet government are other names for the parliamentary system. Further, rule of law. This axiom states that men are not infallible and that hence people are ruled by law rather than men. The statement is essential to a democracy. The notion that the rule of law is supreme in a democracy is more significant. The main component of the law is custom, which is nothing more than ordinary people's ingrained behavior and beliefs over a lengthy period. Rule of law in the end refers to the supremacy of the collective knowledge of the people. Further, integrated and independent judiciary. A single integrated judicial system exists in India. The Indian Constitution also establishes an independent judiciary by preventing the legislature and government from having any influence over it. The Supreme Court of the legal system is known as the Supreme Court. The state level high courts are superior courts to the Supreme Court. District courts and other lower courts fall within the high courts hierarchy of subordinate courts. As the highest court of appeal, the protector of people's basic rights, the steward of the Constitution, the Supreme Court is a federal court. As a result, the Constitution contains several safeguards that guarantees its independence. Further, fundamental rights. 6 fundamental rights are guaranteed to all citizens of India under Part 3 of the Constitution. One of the key components of Indian Constitution is the guarantee of fundamental rights. The fundamental tenets of the Constitution is that everyone has a right to certain freedoms as a fellow human being, and that the exercise of those freedoms is independent of majority or minority opinion. Such rights cannot be revoked by a majority. The purpose of the fundamental rights is to further the notion of democracy. Next one is directive principles of the state policy. The directive principle of state policy is a new aspect in Dr. B.R. Ambedkar's words of Indian Constitution. They are listed in the Constitution's Part 4 for the sake of ensuring social and economic justice for our citizens. The directive principles were incorporated into our Constitution. The next feature is fundamental duties. The fundamental obligations of citizens were not outlined in the original Constitution. The Swayam Singh Committee's suggestion led to the 42nd Amendment Act of 1976, which introduced fundamental duties to our Constitution. The most unique feature of Indian Constitution is Indian secularism. India's Constitution upholds a secular government. As a result, it does not support a specific religion as the state's official religion in India. The idea seeks to create a secular state. This does not imply that Indian government is hostile to religion. The Indian Constitution exemplifies secularism, which is the practice of treating all religions equally or providing equal protection for all of them. The next one is universal adult franchise. One person, one vote is the foundation upon which Indian democracy is based. Elections are open to all Indian citizens who are 18 years old or older, regardless of caste, sex, color, religion or status. Single citizenship. As in the case of USA, citizens of federal states typically have dual citizenship. There is a concept of single citizenship in India. It implies that every Indian is a citizen of India regardless of where they were born or where they currently reside. He or she may be a resident of a constituent state like Jharkhand, Uttaranchal or Chhattisgarh, but they are not citizen of that state. Instead, they are citizen of India. All Indian citizens have equal access to employment opportunities throughout the nation and to all of India's rights. Further, there are emergency provisions. The framers of Constitution anticipated that there might be circumstances in which government could not function as it does in normal circumstances. The Constitution elaborates on emergency provisions to deal with such circumstances. During a crisis, the state government takes complete control of the federal government, which gains absolute authority. Three-tier government. The Indian Constitution originally called for a dual polity and included clauses describing the structure and authority of the center and the state. Later, a third level of governance, local government, which is absent from all other international constitutions, was added by 73rd and 74th Constitutional Amendment Act 1992. So friends, at the last but not the least, I would like to conclude by saying that the Constitution of India took its breath on 26 January 1950 after the intense hard work of the framers and workers. The framers of the Constitution studied the constitutions of other countries and adapted some of the features while creating certain amendments and changes. So, it can't be truly said that the Indian Constitution is a borrowed work or the bag of borrowers, as it is adapted with knowing the historical perspective, geographical diversity, cultural diversity and traditional characteristics of India. And with changing times, certain changes and amendments have also been made with giving special reference to neglected classes and high power to the President of India in the time of emergency. The preamble introduced the Indian Constitution. The Constitution's goals, objectives and guiding principles are described in the preamble. The preamble's objectives have directly and indirectly influenced the fundamental elements of the Constitution. Our Constitution has incorporated the best features of the majority of the main constitutions in the world by national demands. Despite drawing inspiration from almost every other constitution in the world, India's constitution has many unique features that make it stand out from other nations. So friends, this was all about today's discussion. We'll see you in the next module. Thank you very much.